Thank you very much for waiting. We'd like to now start the panel discussion number 1. The theme is the trial and appeal practice in general in each country. So we'd like to now introduce the distinguished panelists. From Japan, JPO, Ms. Kyoko Tamura, the Executive Chief Administrative Judge. From Korea, Ms. John Dowen, Administrative Patent Judge, Board 7 of AP Tab. From Singapore, we have the pleasure to have Mr. Chao Ye, a Patent Examiner, IP Office of Singapore. And from Thailand, we have Mr. Kriyan Sak Ka Onim, a member of the subcommittee of the Board of Patent Department of IP. And then we also have the pleasure to have Ms. Zhang Lin, Director of Intelligence Manufacturing Technology Appeals, National Intellectual Property Administration of PRC. And for Vietnam, we have the pleasure to have Mr. Lee Huey Am, Deputy Director General of IP Vietnam. So those are the distinct panelists. I would like to have exciting panel discussion with them. And now I would like to give the floor to Ms. Tamura, the Executive Chief Administrative Judge, to steer the session. Thank you very much. Well, thank you very much, Togashi-san, for your generous introduction. This is Tamura from JPO. Today we have distinguished guests from various countries, and this is a great opportunity for me, and I'm very much excited and appreciate this opportunity. In this panel discussion 1, we would like to ask questions to the trial and appeal systems of various countries so that we'll be able to qualify the commonality and differences among us. Now, for the Japanese, JPO's response is also introduced. However, because we have the overseas guests, and therefore we'd like to spare more time for questioning the overseas guests. In the interest of time, sometimes I may have to skip some questions, or I may speak about the responses from those countries on their behalf. But please understand that. And for the questions, we are going to entertain any questions from any part of the materials that we're going to show. So let us start. So the page 1, the first question. This is a question, general question about the trial and appeal system. Which kind of trial and appeal system do you have? And if you have it, which organization is going to be the venue for such proceedings? Now we are showing the answers we received from them in advance. Other than Japan, other countries are lined up according to Japanese alphabet. I think that the Korean system is pretty much similar to that of Japan. However, for Singapore, well, actually, there are differences between Japan and Korea, and therefore I have 2 questions to Singapore. First of all, for the appeal against examiner's decision of refusal, the IPOS, you don't handle any of such cases? Am I right in saying that? You don't handle any appeal against the examiner's decision of refusal?
Thank you for your question. In fact, we have a very similar process to appeal. It's not really to appeal. It is a process before the application is refused. So once the applicant of a patent receives a notification of refusal, then we don't really handle the appeal. But there is a process right before the application is refused. That is, after the applicant gets a negative examination report containing at least 1 unresolved issues, and there is still time until they get the notification of refusal. So at that time, they can they can apply for a process which is examination review. So in this process, we will have another examiner to see whether he agrees with the unresolved issues, and also provide the applicant a final chance to submit amendments to overcome these issues. However, if after, let's say, submitting this arguments and amendments, there are still unresolved issues, there will be no chance for them to amend again. Thank you for this question.
Well, thank you very much. So that is to say, there is no appeal and appeal. You are not engaged in the appeal. So regarding the invalidation trial, you have IPOS, and at the same time, High Court. It says that the IPOS and the High Court both are handling the invalidation trial. Which cases go to IPOS instead of the court?
So, if the only issue is to revoke a patent, then this applicant for revocation can choose either IPOS or High Court to deal with this issue. However, if revocation is part of another court case, for example, it is a counterclaim as a defense to an infringement proceeding, and in that case, IPOS will not handle it. Only the High Court will handle this kind of case. Thank you.
Well, thank you very much. So you have a clear roles and responsibilities between IPOS and High Court. And then Thailand. The trial and appeal actually is done by the members of the board selected by the cabinet. So today actually we have Mr. Krian Sak, and he is a member of such board. So I have a question to Krian Sak. So this board committee and also the DIP, what is the relationship between the two? Just briefly, please.
Thank you for your question. For the appeal against the examiner decision or pre-grant opposition, that will be handled by DIP. DIP also have a special group, it's called Technical Advisory Board, which will be nominated by Thai cabinet. That is one of those members is me. There are 12 members. 6 of them will be nominated and endorsed by Thai cabinet. Will be chosen from specialists in the field, and 6 of those will be chosen from officer beside of outside of DIP. So by forming the joint technical advisory board, we will serve 2 things for the appeal and pre-grant opposition. To work as an independent group to give the feedback and draw the conclusions. These are our roles in appeal and pre-opposition. Yes, thank you.
Well, thank you very much. So that means that you have a very important role to play. Thank you very much for your clarification. And then China and Vietnam, well, the patent office is in charge of the trial and appeal. In that sense, the China and Vietnam is close to the system of Korea and Japan. But the trial for correction, you don't have it. So for the question number 1, are there any countries who wish to make a supplemental remark? If not, please go to slide 2, which is about this question 2. So this is a question regarding whether the proceedings done by documentally or the oral. The rules in each country are shown here, but we'd like to ask the question about this. For in Japan, for the appeal against the examiner's decision of refusal based on the written proceedings by law. However, oral can be conducted. However, in reality, written majority. And the Korea, the ex parte shall be examined by document, and for inter parte, oral hearings be conducted. So, would you please tell us the percentage of the oral in ex parte and percentage of the document proceeding in inter parte? Just the rough numbers would be okay, but what would be the percentage?
I will give my best to give. I will do my best to give the answers within my data and the references. My ITEP of KIPO says this morning we didn't have the statistical data about this question, but if I give the explanation more, in practice, ex parte trials or cases in Korea shall be conducted or examined basically through documentary proceedings, in other words, written hearings, by default. Therefore, in the case of ex parte trials, the percentage of the oral proceedings is expected to be very low. But on the other hand, IPTAP has the procedure of the case briefing section for ex parte cases. It was called as technical explanatory section. So upon the request from the appellant or ex officio, and then the percentage of written hearing in the inter-party trials, contrary to ex parte cases in Korea, in the case of the inter-party cases, shall be conducted by oral hearings by default. So we can expect the percentage of written hearing is very low. Yes, so at more, as I mentioned, we do not have statistical data for these cases. Thank you.
Thank you. And I think your case is very similar to Japan. Now I'm going to ask Singapore. For the trials of invalidation in Japan, almost all cases are done orally. And in Singapore, what is the percentage of the oral proceedings for the trials of invalidation? It doesn't have to be a correct number, just for your for the impression.
First of all, I would like to say that we have very few revocation cases at IPOS, so I wonder whether the statistics means anything. And also, we don't have published statistics on which one is conducted orally or which one is conducted as a written proceeding. However, although it could be digged out from the published case summaries, but I checked the most recent two cases there were an oral proceeding. So that is my answer. Thanks.
Thank you very much. So I'm going to ask China, what is the ratio for oral proceedings in China?
Thank you for your question. In China, in re-examination procedure, all your hearing percentage is very low because in the re-examination procedure, the written hearing is enough to fully present the opinions of the petitioners. So the main practice, in practice, the main is written hearing in re-examination procedure, but in invalidation procedure, oral hearing is the main in practice because oral hearing is an efficient way for both parties have plenty of time to focus on the issues of the two parties. So the oral hearing is main in invalidation procedure, and the written procedures percentage is very low. Thank you.
Thank you very much. So that is similar to Japan too. What about in Thailand? in Thailand, you can make a statement when there is additional evidence. So I think the statement is an oral statement, I assume. However, I got the impression that the statements and oral proceedings could be different. So in Thailand, do you do the oral or proceedings or not?
In Thailand, for the pre-grant process or the appeal that handled by DIP and patent committee, we do accept the document. The document itself should comprehensive enough and it should well be prepared, and that would facilitate the process. Because in terms of the oral, so far we didn't consider that yet. Because sometimes we can be mixed with emotion, and emotion can be complicated, and that we see that sometimes if we let that happen, there will be how many oral that you can have, those kind of things, and etc. But coming back to the document itself, so by allowing the channel for document, it can be fair judged by the committee, and that can be ground rules for everyone. So in Thailand, in case that you apply for any kind of application or patent, you can see the process can be straightforward, and you can be happily that you can have enough time to well prepare your document, and your document, if it stands on its own, that would be good for everyone. And I would say, I can firmly believe that the document itself should be comprehensive enough. So for the video, we don't have one yet. And also, coming back to the patent committee, besides of have the technical knowledge in the field, there are one very important thing, and I believe that we trust in that we need to be neutral. So I would go a bit more that for the manual for examiner, we do have the manual for examiner, but for the committee itself, we don't have one in place, because the case can be complicated, and case by case is depend on situation, and they are diversified, and with the growth of the new technology rate, things can be difficult, and that would be really hard to have the previous. Thank you.
Thank you very much for your very detailed explanation. And now I would like to ask Vietnam, what is the percentage of your oral proceedings in Vietnam, please?
Thank you. I would say that in Vietnam, the oral proceeding is written in the law. It is a circular of the Ministry of Science and Technology in 2007, and amended several times. The last time in 2019. And now for the appeal procedure, so the oral proceeding is written in the circular. So it means that oral proceeding can be held during the appeal procedure of IP Vietnam. With regard to the invalidation procedure, the law is silent on that. But in fact, in our actual daily work, we did arrange the oral proceeding in invalidation procedure, but the ratio is very low. For example, in my case, 3 years I work in the Enforcement and Appeal Division. There are only 2 cases. We hold the oral proceeding for invalidation procedure. And the appeal, I think, because we have a first appeal to my office and second appeal to the Ministry of Science and Technology. So I think at the second appeal procedure, normally every time we have oral proceeding at the Ministry of Science and Technology, because my office is under Ministry of Science and Technology. And every time at the oral proceeding, IP Vietnam have to join because we are the person to resolve the first appeal. So that's why we have to be we have to join the oral proceeding at the second appeal at the ministry. So there are three parts in the second appeal. The first part is the ministry. The second part is the appellant, and the third part is IP Vietnam. So do you understand what I mean? And I think and with regard to the written proceeding, written proceeding is obligatory action during the appeal and invalidation procedure. So every time you have to submit the written proceeding. But oral proceeding is required for second appeal cases. But first appeal and invalidation is not obligatory procedure.
Thank you very much for your detailed explanations. So the numbers of oral proceedings are low, but I think when you do, you have to do it many times.
I would say that very low for the invalidation, only 2 cases for 3 years for patent, and very low at the first instant appeal. But second instant appeal at the Ministry of Science and Technology is 100%. 100% is oral proceeding because it is a obligatory action at the second appeal to the Ministry of Science and Technology. So we have first appeal, second appeal, first appeal at my office at IP Vietnam, second at the Ministry of Science and Technology. So second appeal is 100%.
Thank you for your detailed explanation that facilitated my understanding. Thank you. So each country has different situations for the invalidation trials, and many countries have oral proceedings. Vietnam and Taiwan are exceptional. But as for the appeals proceedings, and you have quite wide adoption over oral proceedings. Then question number 3. And we'd like to talk about some of the efforts for determination standardization. And each country has come up with the manuals and guidelines for proceedings, and so as to standardize the decisions. But Thailand answered no manual for the trials and appeals department because of that high level of expertise. So, and for if there are many the examiners, and probably you need a manuals or the guidelines so for the standardization. And I think you can just take a look at the slides and without any furthermore explanation. And the slide number 4 and number 5. This is for trial for invalidation.
Excuse me, could you go back to the slide a bit? In last slide, since I'm not represent the court, in case in trial, it should not be involved in my standing here. And I could not say, currently there is no manual for proceeding of the board. In this sense, is for appeal or pre-opposition, okay? But for the examiner, we do have the manual, and JPO know that very well because we made a trip and we have a good relationship. But the trial is belong to the court, so that should take it out from this sentence. Otherwise, it can be misunderstanding with the Ministry of Justice that I could not be on that, you know. Thank you.
Thank you very much. And as for slide number 4 or 5, for the trial for invalidations. And as for Thailand, and the court is handling the cases. So Thailand describes about the pre-grant oppositions. And 4A, this is for the procedures for the trial for invalidation. And here is only a Japanese explanation only. And we have the different procedures. And we are going to talk about details right now. And would like to, you can come back to this issue later. And as for question number 4A, and can the panel adopt new reasons for invalidation that has not been proposed by the demandant? And some country answered yes, some country answered no. And even though countries answered yes and referred to some restrictions. So I'd like to ask questions of Korea, Thailand, and China. And in Japan, it is possible to adopt, but there are some restrictions, and there is no the conduct for the ex-officer. And so how about the situation in Korea?
According to the Article 159, if you see through the PowerPoint, a panel of judges may examine the reasons that have not been pleaded by a party or the inventor. However, in such case, the parties and interveners shall be provided with an opportunity to submit their opinions and argument within a specified period. But in practice, it's very rare cases for administrative judges. Whether the panel adopted the new reasons, it does not presented by the requesters or dependent, or panel adopt the new evidence other than that provided by the demandant. It's very rare cases. So my IP tab of KIPO do not have any necessity to statistical the data. So, but if I just estimated the rate of this kind of cases related to question 4B and the next question C, the rate of these cases, it would be very low. In practice, we don't have the situation, this kind of case. Yeah. Thank you.
Thank you very much. And there is a stipulation, but quite a rare case for you to refer to that stipulation. And how about the situation in Thailand?
In terms of providing new evidence or to supporting the demandant, in that regard, certainly there is no any restriction by the law, but if the reason fall in the same article, the panel can adopt new reasons. That is what we practice, and we will try our best for the benefit of the party that asks for providing the evidence. Thank you.
And we are now talking about some of the. And is it possible for you to exercise ex officio investigation for the examiners or the administrative judges for the evidence not stated by the demandant?
Oh, you mean the committee by themselves? Typically, we don't intervene with that process because that would be lead to other troubles, and that part will depend on DIP or examinees what would they think of. But for the panel, we will look upon the document. Thank you. Is that good?
Thank you very much. So more or less. So you answered yes, as long as the reasons fall in the same article, but the panel does not seldom write any reasons for invalidation. That's correct? And how about China?
In the PowerPoint, the answer of China is yes. We adopt in some cases, but with strict restrictions. The panel usually, performs examinations pursuant to the scope requested by the petitioner and only on the courses and evidence submitted by parties, and the panel bears no obligation of comprehensive examinations on the validation of the patent. The panel may conduct examinations ex officio in some conditions, such as one condition is the courses raised by the petitioner are obviously inappropriate to the evidence submitted. The panel may change ex officio in the courses to the suitable ones. And number 2 case is a patent obviously falls within the subject matters excluded from patent protection, and the defect is not indicated by the petitioner. The panel will ex officio to accept the reasons, not accept the reasons, to use the reasons in the invalidation procedure. And the third case, maybe a patent have such a defect not indicated by the petitioner as to inhibit further examination on the courses raised by the petitioner. The panel may introduce an ex officio corresponsible course to the defect into the course. So in this circumstance, the panel will conduct ex officio actions, but we will investigate fully in the oral hearing procedure to let parties know the reasons and let him fully present their opinions. Thank you.
Well, thank you for those answers. Maybe the 4B and 4C, maybe we should have combined the 2 questions in one. So once again, those 3 countries would like to restate the question in a clear way. So the different reason for the invalidation, and that is the reasons which is not submitted. Can we use it? For example, if the petitioner says that this is this is because of the lack of the patentability, but then you come up with a different reason, can we also use it for the 4C? For example, this is regarding, suppose that this is invalidation for the inventive step, and then there might be some new evidences available, and can we also explore the new the evidence? The first question is the panel can present the invalidation reason, and second is whether the panel can present new evidences. In Japan, the petitioner for the invalidation trial, it is possible for the panel to adopt. However, in such a case, the panel has to notify this reason for invalidation, so that they'll be able to have the chance for the the amendment or the written opinion. So the Korea, would you like to also once more answer to my first question? And so the new question is the second one. That is whether you can adopt the new evidence.
Yeah, About the question number 4C, in Korea, according to the Article 157, the evidence may be examined or preserved upon request by the party, intervener, or interested party, or ex officio. In that sense, in the case of ex officio request, the administrative judge, we should notify of such fact to the parties and the interveners or interested parties to submit, to provide with the opportunity to submit their opinion or argument thereof. So, as I mentioned above, the rate, related to the rate, is very rare cases. So I estimated it would be very low rate. Okay, thank you.
Well, Thailand. Now, would you like to answer to my questions? Okay. For the invalidation reasons, whether the panel can adopt that. And am I right in saying that you cannot do that? And second, the panel cannot adopt new evidences. Am I right in these 2 points?
For the additional evidence in order to support of the appeal or allegation, shall limited only with the issues stated in the appeal, and the board shall find any facts in the present document in order to decide whether or not the invention is invalid. Yes.
I think that maybe for Thailand, I'm sorry I was misled, but this is pre-granting, the opposition. Therefore, can I ask the same questions regarding the pre-grant opposition? Is the answer still the same?
The answer is applied for the pre-grant opposition. Is not doing anything with the trial, because the trial handled by the court. Because talking about that, many of us might confuse why Thailand doing that, because each country we have their own process, right? But as Ms. Yasuda, Ms. Futoshi pointed out, there are many cases for invalidation, so many, and the court will handle so much. So in Thailand, we will have the process to appeal or for pre-opposition, and this will bring to the patent committee that will help to accelerate that process to make decisions, right? And the question is asking about can we adopt the new evidence, but it needs to be limited, and it should not change the right or obtain the new fact or new claims, things like that. Otherwise, it needs to go back to the beginning. Yep.
Well, thank you very much. So that means that for B and C, although the answer was yes, but actually the yes is in a limited situation. Thank you very much for your clarification. And now going to China. Once again, is it possible to adopt the new reasons for invalidation, and also the panel can also adopt the new evidences? I think that, your answer is that you'll be able to do both. However, the percentage will be low. I assume that will be your answer, but can I confirm that?
Okay, yeah, and I first answer the questions that if we adopt new evidence, the answer is yes, but we adopt new evidence with very strict restrictions. And the panel, in some cases, for example, panel may determine ex officio whether a technical means belongs to a common knowledge of the art and may introduce such common knowledge evidence. So this is the new evidence that not presented by the petitioner, but it is new evidence introduced by the panel. And the other case is panel may use other part of the evidence not alleged by the demanders, and the panel will investigate fully at the oral hearing. And the panel don't change the way of evidence combination. And so it is very strict restrictions of receiving new evidence. And that's my answer. And is there other questions I missed?
それで
Okay.
That's okay. That's okay. That's what I wanted to hear. Well, thank you very much. So, the adoption, you use the adopt. I think that maybe this is the use, the part of the, the new evidence. So rather than when you say adopt, does that mean that you are not trying to find new evidence ex officio, but adopt what has been presented by the demander?
Yes. Actually, sometimes that is not new evidence. Just the panel think maybe most cases is that a technical feature that it is a common knowledge, but to objective to determined. Sometimes the panel will introduce a document. In fact, that is not evidence, but sometimes it is to support the results of the decision, I think. And the evidence, I think it is a lawful document that new evidence we seldom adopted.
So I understood. If it belongs to the common knowledge, then panel sometimes might adopt them. Understood. Okay, we would like to move on to the next question of 4D. So when the demandant proposes multiple reasons for invalidation, does the trial and appeal decision indicate the results of any reasons for determination for all reasons for invalidation and a combination of evidence? And everybody answered the same, but except for China. China said that it would indicate all of the reasons of the decision, but on the other hand, if they show the conclusion that the one of the claim is invalid, then they would not make judgments on the other reasons. And can you explain this? For example, if there are 3 or more reasons for invalidity being presented, and does that mean that only one reason for invalidity is to be indicated?
Let me explain to give more information. And every reason and evidence will be investigated fully in oral hearing procedure. But we have, the panel will not give the primary opinions to the parties, not like a JPO. So the panel in China will investigate fully every reason and evidence in oral proceeding. But before the decisions make, if the panel think there is one reason that could make the patent invalidate, the panel will analyze the reasons in the decision very carefully. And because the claim has been invalidated, so there is no need to analyze other reasons. Because the the claim is invalid. So for examinations efficiency and to speed up the examination's speed, if one conclusion is supported and determined, and withdraw the conclusion. So in the decision, it appears just the only reason that supports that means the claim is invalid, and other reason will not be analyzed, but it will be fully investigated in oral hearing.
Thank you very much. So it would be easy to understand the final judgments, and it would lighten up the burden of the examiners. But on the other hand, if the grounds for invalidation at the trial and appeal board are overturned by the trial court, maybe the two remaining grounds for invalidation could result in multiple hearings at the trial and appeal board. That's the impression I got. Then let me move on to the slide 9, and this is 4E. So we would like to check if the correction is possible for the invalidation trial. And in Korea, Singapore, Japan, the answers were similar. And they said that it's possible to correct. In China, it's possible to correct, but the additional technical features not included in the claim are granted as granted is generally not allowed. So that means that the correction has to be indicated in any of the claim. In other words, correction using terms not specified in claims are generally not allowed. That's how I understood, and am I correct?
In China, it's amended claims must be very careful, and all features will come from the claims granted. The reason is the granted claims should be very predictable for public because there are so many technical features in the description. And if the granted claims did not have the details in the scope of the granted scope, the public will not predict what exactly the claim is. So in Chinese invalidation procedure, correction is very limited, and they can only add features from the granted claims to have better predictable.
Thank you very much for your comment. So we would come back to this point in the IT section with Drone, and I'm sure we can get more comments from China then. And next, we would like to ask two countries who said that no correction is allowed. In Thailand, no correction is allowed, and in Vietnam, I think in some cases you can make corrections. So can you explain to us in which cases you can make correction, please?
So, as specified in my answer to the question, the correction or amendment is not allowed in the appeal procedure or invalidation procedure, except the case that the mistake for the correction or amendment is made by my office. For example, the case that if the applicant want to protect a certain set of claim, but the IP office issue is another set of claim. So I think there are so many reasons that made by the IP office. So in that case, of course, it's mistake from the IP office. So we have to correct it. So that's why I mentioned here that it is made subjectly by the IP office, so we have the responsibility to correct it. If the applicant discover and show it to the office, in other case it's not allowed, because you know that when you correct a claim or correct or amend the claim, the scope of protection is changed. So it means that the scope of right is changed, and it may have a certain impact on any third party. So that's why we have to be very careful with the amendment and correction. And now here, I think maybe if some attorney you have patent prosecution in Vietnam, you may have some problem with the correction relating to the translation of the specification from, for example, English to Vietnamese. Quite a lot of numbers now is awaiting, because the attorney in Vietnam, they want to correct the terms in Vietnamese translation of patent specification. And we are thinking about the procedure and guidelines for that correction. It is under drafting. It is not concluded yet, but we think about how to permit the applicant to correct, not amend. Correct means there are some terms is not in conformity with the original language. So it is maybe, I think in future we will issue a guideline for that, for the correction like that, but amendment is not allowed. If it is not, the reason is not made by the office.
Thank you very much. So corrections are not allowed in most of the cases, and for the mistranslation, you are going to prepare a guideline. You're in the process of preparing a guideline for that, I understand. So let's go to next question 4F. This is the success rate of the demanding for the trials for the invalidation, but there are differences in the system, so it is difficult to compare simply. So I'm not going to touch on the details, so please refer to the document later.
As for the question for G, and this slide number 12, and when the trials for invalidation, is there any special the actions taken if after trial for invalidation is filed for a patent with similar claims? In Japan, yes, and Korea, they have the same. The people should be assigned, and Singapore should shorten the period. So, and would like to move on to the next question. And slide 13, this is for post-grant opposition. And but that's for post-grant opposition. Only Japan and Korea have that system, and those systems are quite similar. So, as for the opposition in post-grant, and probably you can check the slide 17, 13 to 17. Then slide 18, if you go there. And this is for the rate of request for opposition granted. So, in Korea, Korea is not disclosing. But as for ex pariter, the rate, and if there is any opposition, this is just for confirmation of your answers. You are talking about ex parte cases.
Yeah, related to the question 5F, in Korea, we have different name for post-grant opposition. The post-grant opposition is also known as the application for revoking a patent. So totally different name. So the slide shows us the rate of the ex parte, the rate of request granted per ex parte. It means the sum of the post-grant opposition, percentage of post-grant opposition, and percent of the appeal against the examiner's refusal, because the ex parte cases include two trials, not the revocation and the appeal against the examiner's refusal. So if we think of this post-grant opposition, the total number of the petition for the post-grant opposition is very small. So we can guess it affects the total percentage of the figure do not have much effect on the total percentage of exporting the rate. So, anyway, the answer is that this figure included the two types of the request of guarantee. Okay, thank you.
Thank you very much. And for those figures, not the success rate, but as for the ex parte, the proceedings. So you are not exactly talking about for post-grant opposition granted ratio. And then to appeals against examiners' decisions of refusal. And Singapore, the court has been handling that. So that's the comparison of the only 5 countries. And first, the slide 19 and 20 are talking about some of the procedures for that. So we are not talking about the details. And the question 6b, and if there is any opportunity for the appellant to amend the claims and descriptions, and except for Japan and Korea, they cannot. But as for China, they have to meet some conditions, and Thai, Vietnam, they cannot. And as for Singapore, the IPOS does not conduct proceedings for appeal against examiners' decision of refusals. So, is it possible for you to have some amendment or additional explanation, Korea? So, and we have not So as for Korea, and they can correct, and as for the oppositions, they cannot. And 6C, slide 22, and this is for what would you do when you find a new reason for refusal that differs from the reasons in the original decision. And those questions are different. First is for the Vietnam, and it is not stipulated in our legislations. So you have the freedom for notification, or you do not have any defined schemes. And as for the additional research and how it is related to the Department of Examinations, Vietnam.
I think you agree with me that in the appeal procedure, you find a new reason to reject the patentability of an application is not fair for the applicant. I think it is a big mistake made by the IP office, made by the examiner. So in our law, there is no regulation. It is not specified that what can you do in case you find a new reason for refusal in the appeal procedure. But I think it is not so often with patent application, but I think a trademark is sometimes happen. And if you allow the right, the IPR still remain, so it may harm the public, especially in terms of trademark. So that's why even it is not specified in our law, but normally we return the application to the examination unit. And of course, the application have to be examined again with maybe the new reason is included in that procedure. And I think it is not fair for the applicant, and we should avoid to that case happen. I think it is not specified, but we treat the case like that, as I just explained. Yes. It is not specified, but we do like that. So we return the case, return the application to the examination department, yes, for re-examination. Yes, sometimes, but it is very dangerous. Maybe the office may be sued by the, for example, the patent owner for that.
Thank you very much for your quite clear explanation. Then to a question to ask of China. And you said normally. So if there are any special cases, there might be some cases you notify the reasons for refusal. What is the rate or the percentage of that notifications? Quite often or rare?
Maybe I have not the statistics of the rate, but I can introduce some of the cases to provide some information. And our panel normally examines only on the grounds and evidence which the decision rejection is based. But if the panel confirms the existence of the defect after re-examination, it shall make a decision of upholding the rejection decision on the basis of grounds and evidence in such case. For example, the defects for which is sufficient to reject the application on the basis of other grounds and evidence of which the applicant has been notified before rejection. For example, in the substantial examination procedure, and the first notice have noticed applicationer that evidence 1 plus 2 can't refuse the rejection. But the rejected decision is based on evidence 3 and 4. And in that case, in re-examination procedure, if the panel think 3 and 4 is not enough to reject, but evidence 1 plus 2 is sufficient to reject the claim, that we will support use evidence 1 plus 2. That means the claims have no, will not be granted. And in this kind of procedure that maybe shorten the examination's time period, because if the re-examination just examined the evidence 3 plus 4, it will be back to the substantial examination. But the examiners think evidence 1 plus 2 is will reject the claims, and it will again into the re-examination procedure. It is a long, it's waste of time. So in this case, and the panel will use evidence 1 plus 2 to make a decision. That is the case. And the other is if the defects which are not indicated in the decision of rejection, but are obvious and substantive or of the same nature with those indicated in the decision of rejection. That means the basic is the same. That means if the claims will not be granted for reason that has been told the applications, and to shorten the examinations period, we will use the reason that different from the rejection decision. And but in this case, the panel will notify the applications of all the reasons for refusal found, and gives the applicant plenty opportunity to submit a written opinion. That's my answer. Thank you.
Well, thank you very much. The return to the examination board, does that happen often? Or in some cases, return to the examination board, but to the extent that you are able to make a decision at the TA panel, you do make the decision at the TA panel. Am I right in saying that?
Let me confirm the information that I got a red message. Do you mean, is it very often to have to in this case? Not very often. Just case by case, that the basic idea we hold that we substantially examine the patent. If it will be granted, it is the base rule. If it will not be granted on the said evidence, we will make a decision. But the case is not very much that the reason is different from rejection decision. Am I got the right information from you?
I think you're okay. I think I understand your point. So during the examination, the reason for the refusal is known, and there is 1, 2, and 3, and 4. And 3 and 4 cannot be supported, but the 1 and 2 can support. In such a case, you take the 1 and 2. But that trial appeal panel, I know that you will sometimes notify new reasons, but sometimes do you return the case back to the examination panel? That's the first thing that I want to confirm.
If the claim have not inventive step based on 1+2, it will not back to the substantive examiner. It will make decision on the panel decision that the claim has not have no inventive step. It will not back to the prior examiners, and it will conclude it in the re-examination procedure.
And thank you very much for that. I think that the time is on. So for Thailand, it says that you have no power to notify, so that means that you don't make a notification, but you will make a decision without the notification. So just quickly, you can answer yes or no at the board. Excuse me, when you are not able to support the refusal of examination result, do you think you're going to turn this case back to the examination board?
I think practically, if the person who asks for such claim and they accept it at the beginning, and even though the board by itself has no power to notify or to invoke in such a decision. So it depends on the person who demand for the right or for the protection or for such invention that need to come up and makes the appeal. Yes. So for it has nothing to do with the board. You know, that's what I'm saying. Because so many things that we need to take care. And if we found a little bit like kind of the board went to the bed and has the nightmare and then just suddenly wake up with the new things, that's the reality, you know. And the person who in charge or ask for it need to take care of that. And that I think that is the process in general. As the representative from China say, it's very rare case. And exactly for that rare case, I would be happy to see the real case, because it's, to my knowledge, in our experience, we don't have one. Thanks.
Thank you very much. Well, Korea, lastly, in Korea as well, it looks like you are able to notify the reason for the refusal, but what would be the percentage of that happens? And I also like to know the relationship with you and with the examination board in terms of, for example, sending back or the remanding and so forth.
Most of my answer about the many questions are inclined to the uncommon cases, include question 6C. When there is new reasons for rejection, the administrative judge serves the notice of submission of written opinion by appellant. In practice, it is not usually or not common in overall cases include the different technical fields. So, but in the chemistry field, I have a few cases in my whole experience of administrative judge. So my IP tab of KIPO does not have the statistical data for these cases because very rare and very small cases. Yes, thank you.
Well, thank you very much for that. In Japan, while you are not able to support, even that case, we do not return the case to the examination board, and instead the administrative judges find the new reasons and ex officio and make decisions. But as we look at the responses, this case, it is rare at this stage. It is rare to find the new reasons. So I think that the Japanese way is rather rare and different from other countries. I'm sorry that we are getting very hasty, but if you go to slide 23, this is the percentage of requests granted for the appeal against the examination decision for refusal, because we are not able to make an apple to apple, and therefore please look at those data in your spare time later. And slide 24. Actually, this is something that somebody else wanted to ask definitely. And this is the one portal dossier, for example. Are you confirming the examination status of the corresponding foreign patent? Well, actually, in Japan, we are utilizing OPD to confirm the examination status in other countries. And I think that so is Korea, Singapore, and Thailand as well. And so I have a question to Singapore. So in Singapore, you said that you defer only conditionally. So, what are those conditions when you refer to OPD?
The condition is exactly as what is shown in the slide. There must be at least one party that brings this foreign prosecution up in the proceeding. Well, usually this proceeding should be at least beneficial to one party, and it is such proceedings are such foreign prosecution information is also public and very easy to get. For example, from the OPD. So, if they think it is useful to their case, of course they will use such information. Thanks.
Well, thank you very much. It was a very clear, correct answer. And then quickly going to 25. It is quite self-explanatory. Any operations or initiatives at the office developed in light of the judicial precedent in almost all countries. I'm sure that you are taking some efforts. In Korea, you are making many documents and materials. Do you think that you want to add something here from Korea?
Yes. My IP tab of KIPO, Korea, has published a lot of other materials, except for the slide 25, number 1 and 2. And also I introduced the various kinds of the material related to the question number 3. And we published at first we published the case book, that summary of the patent and Supreme Court decision by different technical appeals to give the better opportunity to current trend in the latest the court decision for the administrative judges. And more, another publication include the fundamental guide to IPTAP proceedings and oral hearings guidebook or manual for standardized or written decision in order to help the administrative judge with a different year of experiences from the beginner, the newly appointed judge, to experienced IPTAP judges. And also we hold the quarterly the discussion on landmark cases based on different technical fields, and we have the recent IPTAP and court cases. And also IPTAP has a research and working group on patent litigation practice, which involves 7 relevant organizations, including KIPO IPTAP and District Public Prosecutor's Office, and High Public Prosecutor's Office in Daejeon, and 2 universities in the law school. And also we hold the search meetings and seminars about patent litigation 6 times every year, so every 2 months. It's very helpful to ensure high quality of trial and appeal and litigation proceedings. And we discuss and study legal and technical IP issues together with academia. The more important thing is all of these materials are provided in e-format, the computerized system. We can be available on the IPTAP website. Thank you.
So I understand that you have a very full lineup of publication. Thank you very much. So we'd like to move on to the oral proceedings, and I'm going to move on to 9A. And this is the question about ideas to facilitate the smooth conduct of oral proceedings. And amongst those countries who have such conduct, can I ask Singapore to give us the example of such actions to facilitate the smooth conduct of oral proceedings, please?
In fact, we have, to smooth the conduct of the oral proceeding, we have one case management conference before the oral hearing. But in fact, in the process, there are a few case managing conferences. The first one could be held after the 2 parties submitted their facts and their arguments. And then there will be a conference to discuss whether they want to proceed or do they want to engage in like alternative resolution options, things like that. And after that, if they wish to proceed, then they will submit evidence to their facts. And then after that, after the evidence are submitted, there could be another case management conference to see what is the evidence and whether there should be any re-examination that engaging the examiners. And then after that, it will be the hearing. But before the hearing, there will be this. I think this is the most important case management conference, which sets out the parameters of the hearing, and then they will discuss the conduct of the case, and the parties will also be asked to prioritize their prior art and reasonings, so that we make sure that the most important reasons of prior art are always dealt first. So I think overall there are a few management conferences that help smoothen the whole process of the revocation proceeding, but the last one is the one that helps with the actual hearing. Thank you.
Thank you very much for explanation. So I was going to ask Korea and China to respond too, but because of time limitation, I would like to move on to the next question. Moving on to slide 27, this is about the online oral hearing, and I think all countries answered that it's possible. But I think the usage rate is somewhat vague, so if you can just give us that simple numbers, that would be helpful. From Singapore, what is the ratio of online oral hearing? What is the rough number, please, if you know?
I'm very sorry because I don't work in the hearing department, and this type of information, I don't think it is publicly available.
Okay, thank you. What about Vietnam? The online oral hearing, what is the percentage?
It is allowable, but no case happened during COVID-19 pandemic, but it is allowable even now, but it is not happened yet.
Thank you very much. So maybe this might happen in the future. Thank you so much for this opportunity. We were able to deepen our understanding about this appeal system in different countries. So we'd like to conclude panel discussion 1 now.